Welcome back, Law Nerd, to another episode of The Emily Show. Happy Monday, and we have a lot to talk about today because on stream and elsewhere, I've been getting lots of questions about the David Preliminary Hearing. Yes, the singer whose name is David, but he goes by the, well, professional moniker of David spelled D4VD instead of DAVID. But we're going to talk about that preliminary hearing today. There are a lot of details that have come out at the preliminary hearing that line up with what we saw from the prosecution's preliminary hearing brief. We will talk about that brief a little bit, but not in depth because we did cover that on a previous episode. And as always, we will be going through this to talk about what the legal part of this is. I will not be getting into every detail that we learned from court. I will not be getting into some of the more horrific details coming out of court, describing the photos shown in court and things like that, because I know that for many of you, this case is an absolute nightmare and you want to know what's happening legally without knowing every single detail. And some media has done really well to be transparent, but also not be overly sensationalistic with it, and some not so much. There's tons of coverage of this case. If you are looking for more details about what is coming out in the courtroom, if you want to know the legal process, what evidence the prosecutors are showing, and what happens next, stay tuned. I've got you. So let's get into the Emily Show. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is the Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. Law Nerd, it is that time of year where you know I have been out and about, sitting in football stadiums all over this country, watching my kiddo do DCI marching, and the thing that I cannot travel without is my Oneskin sunscreen. Oneskin actually has two specific lip SPFs. You can get them either a tinted or just a regular lip SPF, but they don't make your mouth taste weird. They don't have a weird white cast. Oneskin knows how valuable sunscreen is too. 80% of visible aging starts with sun exposure. Oneskin's new limited edition summer bundles have you covered. It's their skincare and SPF essentials paired together so that the OS1 peptide is helping to reverse the visible signs of UV aging while you're getting the SPF protection from new damage. Oneskin results are backed by 4 peer-reviewed clinical studies and over 10,000 5-star reviews. Plus, they've been recognized by Bloomberg as a leader in skin longevity. Born from over a decade of longevity research, Oneskin is helping you unlock your healthiest skin now and as you age. For a limited time, try Oneskin with 15% off using code LAWNERD at oneskin.co/LawNerd. That's right, 15% off at oneskin.co with code LAWNERD. And after your purchase, if they asked how you heard about them, let them know it was the Emily Show. And now let's get back to it. Law Nerds, yes, I was traveling to see my kiddo, and it does help my mama heart be able to give my kiddo a big hug before covering this case, because this case is just so incredibly difficult. And it does not matter that I prosecuted for as many years as I did. I don't think there's anyone that this case is easy for. That includes the judge, the defense attorney, and the prosecutor in this case. This is the type of case that is going to stick with everyone who had to work on it for way too long. What I hope is to be able to cover it today without it sticking with you in the way of there's things you can't unknow. So let's talk about where we are in court in Los Angeles. We are going through the David preliminary hearing. Let's talk about 1, what David has been charged with, and then 2, what a preliminary hearing is as we go through this case in Los Angeles. And as a note, you are not going to see clips from the courtroom or clips out of court. The judge in this case, Judge Olmedo, has made a ruling at the beginning of this case that there will be no cameras in the courtroom for the duration of this case. Preliminary hearing, motion hearings, and the trial. And part of that is because of the charges in this case. And I think it's helpful to take a look at what those charges are, because I've seen some reporting that seems to forget exactly everything he's charged with. And that's not really helpful, because when we get into the evidence of what's being shown at the preliminary hearing, the reason that things are being presented is because of what he's charged with. Because the purpose of the preliminary hearing is to show that there's probable cause to think that the person who is in court did the things they're charged with. So a good place to always start is with the charges. So we were looking at the felony complaint filed April 20th, 2026. Count 1. I'm not going to read every single word of this, but count 1 is murder in the first degree, and it is alleged that that is a special circumstance murder. The special circumstances in this case are: 1, that the murder of Celeste was intentionally carried out by David Burke for financial gain. So that is pecuniary gain, financial gain. I will use those two things interchangeably. We saw this in the Corey Richards case recently as an aggravator. Remember, some jurisdictions refer to that, first degree murder plus as aggravated murder, some jurisdictions as special circumstance murder. And then we talk about aggravators or special circumstances in addition. Here, the special circumstances are: 1, the financial or pecuniary gain, and 2, the killing of a witness, that Celeste was a witness to a crime and was killed because of that. So keep in mind that this is not motive evidence per se. These are also circumstances that need to be proven to take this from just being, and just sounds too simplistic, but that takes this from being a first degree, willful, intentional murder with malice aforethought. It takes it from being that first degree murder into being a murder more with those special circumstances. So these go beyond motive evidence and go to proving those special circumstances. And when this goes to trial, a jury will have to find each of those special circumstances, like we recently saw in the Corey Richards case. It is also indicated on count 1 that there is a additional charge here that David personally used a dangerous or deadly and dangerous weapon, a sharp instrument. So that is the weapon enhancement that's charged as to count 1. We will hear about that within the preliminary hearing. There is also count 2 that between September 7th, 2023 and September 7th, 2024, that there was the continuous sexual abuse of a minor, that being Celeste, a child under the age of 14, as laid out in Penal Code 288 by David, and that he unlawfully engaged in 3 or more acts of substantial sexual conduct. That's all defined within the law, but I will call this generally the ongoing sexual abuse or ongoing sexual abuse of a minor. That is part of what's charged here, but it's also part of why the judge does not want cameras in the courtroom. Count 3 is the unlawful mutilation of human remains. That was charged on or about May 5th, 2025. So those are the 3 counts: the special circumstance murder, the continuous sexual abuse of a minor, and the dismemberment and mutilation of Celeste. So throughout the preliminary hearing, in its first 4 days, because this preliminary hearing started on Tuesday, July 21st, and is continuing on Monday, July 27th, the day this episode goes live, I would suspect that it would probably wrap up on Monday. I don't know if we will see the judge ruling from the bench and holding this to answer on Monday, or if that will come later. Neither would surprise me, truthfully. It's common in Los Angeles that things are just held to answer at the end of the preliminary hearing, so that would not surprise me. So let's talk a little bit about what is a preliminary hearing. We've covered this in other episodes, and I am still surprised when I'm looking through articles talking about this case from those in the courtroom, how many still refer to it as a trial. And it's one of those things where I'm just like, lawyer Emily is like, no, actually it's not. There's no jury. There might be people sitting in the jury box. There might be attorneys. There might be law clerks. There might be people sitting in the jury box, but there is not a jury. And this is not proof beyond a reasonable doubt. This is a preliminary hearing. It is a probable cause hearing. A lot of jurisdictions do this through using a grand jury. And yes, there was an investigative grand jury in this case, but the grand jury did not charge David, which means they did not go through a grand jury indictment. It was an investigative grand jury. And so the grand jury wasn't the charging body, so you didn't already have a probable cause hearing. This is the probable cause hearing. So what the judge needs to determine is whether or not, based on the evidence presented by the prosecution, there's probable cause to bind David over for trial or hold him to answer on these charges and all of these charges, which means the prosecution has to prove the elements of each offense, that it happened jurisdictionally within Los Angeles County, and that it was done by the person in custody, David Anthony Burke, and that the victim is the victim. That is your basis of preliminary hearing. So what the prosecution is going to show to the court is not going to be everything known in the case. It is not going to be as in-depth as a trial, and the rules of evidence are not quite the same. You can use a lot more hearsay because it's not really hearsay at the probable cause hearing. So there are different rules for that. So you will see in us talking about this that there are some images that aren't displayed in court. They are described by detectives. At a preliminary hearing, that's completely appropriate. There are times you will have detectives relay things that they learned from other individuals, or even give what another individual said to them in an interview as testimony. Those things are allowed at preliminary hearing. The DA in this case, Beth Silverman, has also used civilian witnesses to come in and give testimony at preliminary hearing, which gives the defense an opportunity for cross-examination. Remember, if this went through grand jury, the defense would not have an opportunity for cross-examination. It would happen at a secret grand jury with the prosecution and the witnesses, and then the grand jury would make a decision. The defense would not be involved in that process. And this is in a public and open courthouse. So even though there aren't cameras in the courtroom, there is media in the courtroom. The public is allowed to be in the courtroom to watch what happens versus a grand jury. You don't have any observers. You have the grand jurors, prosecutor, judge. That's it. So this is a much more open process. What happens after the preliminary hearing? Well, based on what we are going to cover today, I expect that the judge will hold David Burke to answer on all of the charges in this case. And after that, it will get bound over for trial. This case has been specially assigned to Judge Olmedo. That means it's going to stay with the same judge after preliminary hearing. Might we see the defense make some kind of bail or bond motion? Maybe, maybe not. But at this point, he remains detained on no bond. And in a special circumstance murder case, that's not surprising to me that he would remain in custody on no bond throughout the entirety of this case up until trial and go from there. What else might we see? Well, after a preliminary hearing is held, there will be a pretrial hearing set. You will see motion work, and the prosecutors will take this case to their special circumstances committee that includes the head elected district attorney of Los Angeles and then other members of the committee who will discuss what punishment to seek in this case. And that will really direct how the case moves towards trial. California does have a moratorium on carrying out the death penalty, which means the state of California is not carrying out that punishment, but it still remains on the books in California, so it can still be a punishment. You can still go to trial and have a jury find someone guilty and then do a penalty phase on whether it's a life in prison or a death penalty case. But at the district attorney's office in Los Angeles, that's determined by committee, and the defense has the ability to submit evidence that they want considered at that committee hearing. And so the defense does have the ability to give information to the prosecutor's office and say, please consider these things in making your decision. Once that decision is made, it will really set the trajectory of the case for trial. There is a lot more work that goes into a death penalty case than a case where life without parole is what's being sought. We saw a lot of conversation about this in the Kohberger case, how much work the defense needed to do to get ready for both the penalty phase of the trial and then the sentencing phase of the trial. If it does go to trial seeking the death penalty, there is a lot more that the defense will have to do. There will be those two phases of a trial. Jury selection becomes much more involved and in depth, and the case can take longer. It will also have a much longer tail of the appeals process, which we discussed again in the Kohberger case, where there were pros and cons of not going to trial in the Kohberger case, and cutting off that very extensive appeal tail is part of it. So the path towards trial will really be determined by the district attorney's office decision there. And so after this is held to answer, that's really the next significant phase that I will be keeping an eye on is what the DA's office decides to do, and I'm sure the office will announce it at some point what they decide to do. Yes, there is another case that's potentially a death penalty case from the LADA's office now that we have been covering, the Nick Reiner case. That's not even back for preliminary hearing setting until September, so we're really not going to hear much more about that case. And remember, that case is going through probate, as we've talked about in past episodes, because Nick Reiner wants access to some of his trust fund money that was funded before his parents' murder and wants to be able to hire representation using those funds. Not so much of an issue for David, who does still have access to his money, and we learned a lot about that at the preliminary hearing. Why do we hear so much about David's money? Well, because special circumstance for financial gain is one of the counts here, and talking about how his career was going and what his career might lose if it came forward that he was having an inappropriate sexual connection to a minor. Well, what does he stand to lose? And as we get into the preliminary hearing, just know that yes, there will be timestamps down below, but we are going to talk about some of the things that were discussed in court, and they are incredibly disturbing. Even when we talk about them without getting into all of the details, the facts of this case are disturbing. They are difficult. And so, Lawnards, I trust you to know yourself. And if you need to nope out of this case, it's okay. The timestamps are there, which is why I covered kind of everything I thought you might want to know before we got into what we've learned at preliminary hearing. And so as we begin to talk about this preliminary hearing, we will start to get into the facts as they have come out in court. And again, this is all through media reporting. One of my big frustrations is every time I see someone say jury or trial, but you know what we mean. So when you are looking at any reporting on this case, just know that it's a preliminary hearing. Sometimes the media just doesn't understand. It's not a trial. It's not a trial. It's not a trial. It is going to be 2027 or 2028 or possibly later before we see this case go to trial. And there is going to be a lot of contentious litigation between now and this case ever going to trial. So let's talk about some of the things we learned at this preliminary hearing. Lawnard, if there ever was an episode where you might just want to wrap yourself in a cozy blanket because you need a hug, this episode might be it. And today's sponsor, Lola Blanket, has you covered with literally the most comfortable blanket for whatever kind of comfort you're needing. I remember when Judge Abby sent me my first Lola blanket and she was like, this is literally the softest thing ever. And now it's become my go-to gift to give as well. It is the world's #1 blanket. It's luxury faux fur. It has 4-way stretch and it has easy care. It's built to last for years and it stays flawless, which makes it a go-to gift, especially when you just need to send somebody a hug from afar. And they have a ton of different colors and textures that you can choose from. So no matter who you're gifting, you know that you're gonna get it right. Lola Blankets literally has something for everyone. And you know what we have? A deal for you. Because of course we do. For limited time, you get 40% off select Lola Blanket products with code LAWNERD at checkout. Just head to lolablankets.com and use code LAWNERD. And after your purchase, if they asked where you heard about them, let them know it was The Emily Show. Get ready to wrap yourself in luxury with Lola Blankets. Let's get back to today's episode. First, there were some discussions about this case. I mean, many discussions about this case that we had an inkling of, but we maybe hadn't known for sure or where it was coming from yet. But we did learn that David started having communications with Celeste when she was 11 years old. And they began having physical, sexual relations when she was 13. And again, in this case, if I use the word, I just want to make a caveat here. If I use the word relations or relationship, I am not indicating that this was anything other than the grooming of a minor. It is just trying to indicate the contact that the two of them were having in the contact that the two of them were having. He was an adult. She was a minor. She did not have the legal and lawful ability to consent. This is not a consensual relationship because she was a minor and did not have the ability to consent. And the discussion of their contact will be kind of towards the end of this episode. So that if that's where the absolute nope out is, we're going to get to that towards the end of me talking about what comes up in the preliminary hearing. I'm not necessarily going in order of the days of the preliminary hearing, but I just wanted to make clear that this is not, and even when I say inappropriate relationship, whether or not the victim in this case viewed it as such, legally, she is a child. And so that is not a relationship. He is an adult. She is a child. She cannot consent. Period. So let's start with talking about the money. There were numerous witnesses that testified, civilian witnesses that testified, not just about how much David had made in his contract with Interscope Records. A finance executive from Interscope testified, and they indicated that he had made more than $7.5 million with his recording contract prior to the discovery of Celeste's remains in September 2025. Remember, prosecutors alleged that she was killed in April of 2025, and Interscope did not drop him from the label until December 2025. He wasn't charged in this case until April of 2026. But in September 2025, Celeste's remains were found in the front trunk of a Tesla registered to him. And then shortly thereafter, the internet unearthed quite a lot of information showing the connections between the two of them, including things like matching tattoos. So the connection between the two of them was fairly sussed out on the internet before we even got a charge in this case. And what we learned in the preliminary hearing that is something I did not know going into this from what we have seen the prosecutors put in their briefs, etc., is that when Celeste's remains were found in the front trunk of the Tesla registered to David, it was her father that called law enforcement, concerned that the remains were hers, put law enforcement in contact with her dentist, and that's how they were able to get dental records, which were ultimately used to identify her because the decomposition was such that dental record identification was in fact needed in this case. But knowing that her parents were sitting through parts of the preliminary hearing and quite a lot of the preliminary hearing over the 4 days that it's been ongoing, I can't imagine how difficult that testimony is for them. I also can understand the push-pull of wanting to know and wanting to also bear witness to the process as it's happening. But also there's some things you just can't unknow. And there are things from this preliminary hearing that are going to count as things you can't unknow. But we did learn how dental records were obtained to begin to identify her. It's because her family was concerned that it was her remains. And a representative from David's management company, that is still his management company, testified that he had grossed between $10 and $11.5 million between 2023 and 2025. And that after Celeste's remains were found, that in fact, David's mother had been in contact with the finance manager, asking to move David's home into her name and continuing to manage David's money, that there were concerns of a civil lawsuit. Of course, they're concerned about a civil lawsuit. There will at some point be a civil wrongful death lawsuit. The family's civil attorney has been in the courtroom throughout the preliminary hearing. And again, this is one of those points where if you have a family lawyer that's representing you, they can also be the one to witness this preliminary hearing if members of the family are like, I don't want to do this, because that would also be a fair way to go about it for sure. But there was concern about a civil lawsuit, it seems, prior to David being charged, because of course there was. She was located in the front trunk of his vehicle. And it sounds like his financial manager is still on payroll to the tune of like $7,500 a month and is still seeking a new entertainment lawyer for David, which I was surprised came out at preliminary hearing. I'm surprised it's happening, honestly. I'm not sure what rights need to be managed. He's been dropped from his label. I can't imagine there are like licensing issues that need to be done. Maybe he needs an entertainment lawyer to try to complain if companies have canceled his contracts. I think that his skin and emote were taken out of like Fortnite, but I imagine all of those contracts probably had some type of morality clause where you can't go after the company for removing him from contracts after a dismembered child was found in his vehicle. So I don't know exactly what he needs an entertainment lawyer for, but apparently his money manager is still money managing, and that's ongoing. But the civil lawyer must have been like, well, check, that you're trying to now move assets because you're concerned about a civil case. I find that's a day of transcript that the civil attorney is immediately going to want to say, look, we know he moved the house because he wanted to avoid this civil early on. So we should be able to track down those assets. So I guess that's helpful testimony for the civil attorney coming out of the preliminary hearing, because I'm sure that they will pursue a wrongful death lawsuit. And whether they pursue that before the trial is over or after, we will just have to wait and see. And one thing to keep in mind about that is generally in California, that civil wrongful death statute will run from 2 years from the date of the death. In this case, the prosecutors are alleging that that death occurred in April of 2025. However, the discovery of the death in September of 2025 may change some of the arguments around statute of limitations. Either way, we are past the 1 year mark in April 2026 and really have until April 2027 until you hit that 2 year mark with regard to the prosecution's date of death. But you may have some caveats for date of discovery because Celeste was a missing person until her remains were discovered in September and then identified later in September. That's probably more nuanced than we need, but it's something to keep in mind because the statute of limitations is simple and finite. Well, I guess it's not always simple. It is in fact finite. One of the questions I had going into this preliminary hearing that we've talked about a bit, because one, I'm from Southern California, and two, it seems still so odd to me that the timing of everything that the prosecution's alleging, and it seems that all the digital pattern of life seems to indicate that Celeste was killed in April 2025 and that Tesla wasn't discovered until September of 2025 and what happened in the in-between. But at the preliminary hearing, there was digital evidence discussion about who was the last driver of the Tesla and when it was last driven. And I was actually quite surprised by the answer. The Tesla had not been driven since July 29th, 2025. And the prosecution argued that David was the last person driving the vehicle and it did not move again until it was towed, which is bananas to me that Los Angeles street sweeping didn't tow that shit way earlier. However, July 29th is the last date it was driven. The Tesla connected to David's cell phone and they were using his cell phone to connect that Tesla, but they also have a full thumb drive that they pulled out of the Tesla. Teslas take all kinds of video. I wouldn't be surprised if we learn down the road that there's also video of David driving it. It's not just them connecting the cell phone to the use on the Tesla, but prosecutors presented evidence that David was the last driver of the Tesla on July 29th, 2025, and then it never moved again. They showed photos of the Tesla in court. It had quite a layer of dust and had quite a few air fresheners placed into different pockets around the car, which did not help because it was apparent when the car was towed and when it got to the tow yard that something was not right. And they went into more detail about that during the preliminary hearing. The coroner also testified and went into detail about the apparentness of the decomposition, not just visually. Speaking of the coroner in this case did testified about the dismemberment of Celeste, the decomposition of Celeste, the pieces of blue plastic that were on her remains that seem, well, to me, this is Emily interjecting, that seem to me consistent with a blue plastic inflatable pool that we have heard quite a lot about that also had cuts in it that seemed to be where he might have put Celeste to dismember her. That was also tested and recovered and had a dryer sheet in it. It seemed that it had been laundered like through the washer and dryer to launder it, but they do physical match analysis with pieces of that plastic recovered from Celeste and pieces of plastic from that pool. There was some physical match done on that by the crime lab that did match. So I don't think it is going to be a stretch that that is what the inflatable pool was used for. In addition to crime lab analysis and physical match, there was also lots of testimony about DNA, including the fact that single source DNA matching Celeste was in different places in the interior compartment, the passenger compartment of the Tesla, in areas that had tested presumptively positive for blood, that there was also lots of areas within the garage that tested presumptively positive for blood, and that the DNA from those areas matched back to Celeste. But I have gotten far afield from talking about the coroner's testimony that included the sharp force injuries to some of Celeste's internal organs that were able to be seen. That decomposition doesn't change that, except that the coroner would have perceived those injuries to be deeper into her organs had she not been so decomposed. There was also injuries to her rib bones from an apparent sharp object, and there was cross-examination on all of those facts during the preliminary hearing. Again, we talked about this a bit because it was in the prosecutor's preliminary hearing breakdown, and we've also talked about the autopsy report a bit, but the coroner was able to determine very readily that the manner of death here was homicide, meaning caused by another person, and that the cause of death was multiple sharp force penetrating injuries. And that's why we see in the charging documents that it doesn't say use of a weapon, a knife, or a this or a that. It simply says a sharp instrument, because it could be a variety of things and they have not narrowed that down. And when it goes to trial, they don't have to. They may, but they don't have to. And now we are going to get into just a little bit of the evidence that was presented in court regarding the other counts here, both the continuous sexual abuse of a minor and the special circumstance killing of a witness, because the allegation there is that he was killing Celeste to keep her from exposing the inappropriateness of their relationship and what he was doing to her as a minor, and protect his career, reputation, and money. So that is both the witness, she is a witness to the things that are happening to her that are a crime, and also the pecuniary gain, because her coming forward as a witness messes with his entire career and would be devastating to his entire career. And the prosecution relied heavily on digital evidence of not just their text messages together, but also photos and videos, and a substantial amount of photos and videos that indicate the sexual activity between the two of them, and that documented that fairly thoroughly. That was not shown in court. That was done by testimony from the detective. That is the type of evidence that is not turned over in discovery. It is held at the police department by their unit that only handles sexual materials of children. And so if the defense wants to review it, they have to go to the police department to do that. But when this goes to trial, testimony of a witness is not going to be sufficient on that count. Though I wonder if we might see a situation where the defense tries to plea to that count so that the jury does not have to see that information in the homicide trial, does not have to see those videos in the homicide trial. And that is something that can happen. The defendant can plead to some of the counts and not all of them, though the prosecution will argue that some of the information, maybe the text messages only, will need to establish why he was going to kill a witness, because she is a witness to the things that are happening to her. But I'll be curious to see what the defense does with that. I imagine trying to limit the amount of that a jury has to see would be something that the defense would strongly consider, particularly with how much of a reaction people have to that type of evidence, no matter what, because of course they do. And again, if it's on his phone, videos of him, of her that he is taking, It's hard digital evidence to get around as the defense. That was described in court by the detective. The text messages were described. The thing that I was not aware of in the text messages being described, I mean, there was much, but we're going to narrow it in, is one, that text messages between Celeste and David indicate that David's mother was well aware of their relationship. And that I found surprising. Apparently, when he bought tickets for them to travel, because they traveled out of the country, I still have a lot of questions about that, but they traveled out of the country to London and then to Texas to visit his family. So he took Celeste to visit his family. His mom knew that they were in a relationship per text messages, and her plane ticket clearly indicated her date of birth and that she was a minor. And there were messages between the two of them talking about her terminating a pregnancy when she was 13 years old. At that point, he was 19 years old, and continuing to have discussions about it, her continuing to have discussions about the impact that that had on her. And that is something that seemed from the text messages shared in court to be weighing heavily on her, and that she kept bringing up to him about wanting to make sure her cycle came, about not wanting to get pregnant again, along with text messages of her saying, all you want to do is hang out and have sex. And I want more. Her exact words were, and I want more than that for myself. Absolutely gut-wrenching messages between the two of them shared in court. And through all of this, we have seen the media report on David's demeanor in court. Again, I don't know if there's any correct demeanor for a defendant. They shouldn't have outbursts in court. Their attorneys will tell them not to have outbursts in court. There is not really much a defendant can do except sit and be fairly stoic. If they are overly emotional, they will get told by the court that they need to rein it in. But then again, if they show no emotion, then the media will say that they are sitting there emotionless. It is what their attorneys will tell them to do, to not react to what you see in court. And so I comment on it just to say that there is little a defendant in court in a preliminary hearing can do except be fairly restrained in court. And speaking of restrained in court, you might have heard some conversation about whether or not David would be in restraints in court. And the court allowed him to have his hands free at counsel table, but to still be in waist chains and shackles. That's fairly common for a preliminary hearing. And again, there's no concern at a preliminary hearing that the jury could be biased by seeing him in waist shackles. But even if and when this goes to trial, it would not be unusual for him to be in a waist chain and ankle shackles because the jury won't be able to see it under the table. When it goes to trial, he will be seated at counsel table before the jury comes in. The jury will be gone before he's moved out of the courtroom back into lockup, and his hands would be free and he would be in civilian clothes, but he can still be shackled under those. That's not uncommon and probably what we will see if this goes to trial. But this is by all means a difficult case with really difficult evidence by any account. I will continue going through the legal processes of what's happening in this case. I know many of you want to know what's happening, but also it's worse. It's just worse. The prosecutor's brief was difficult. We knew that the evidence in this case was going to be difficult, and yet somehow it just keeps getting worse. And when it goes to trial, it will be worse. But this is a judge who is going to keep this courtroom reined in. This is a prosecutor who is not going to blink at all on this case. I imagine David's lawyers have told him that Beth Silverman is not going to be messed with by anything, and she's not going to be shaken off her game. And Blair Burke and Beth Silverman have been in trial before. Also, between Beth Silverman and Blair Burke and Judge Olmedo, I want to go watch court a few days. I really do, because this is a judge who is not going to let things get out of control. These are two attorneys who have history working together in the courthouse that I used to work at. up on the 9th floor, there is a part of me that's just like, I want to see all of those moving pieces in action, because Beth Silverman is a great prosecutor. Blair Burke is a great defense attorney. And you have a very strong judge on the bench, which means that all of the difficulty of the evidence aside, there is also going to be some very good lawyering and, I imagine, some contentiousness, which I've seen a few articles note that there were moments of contentiousness, including the media noting a moment where the judge said to the attorneys that perhaps their prior work together was causing or underlying some of the contentiousness between them in this case. So I am interested in the lawyering here and to see what happens. But LA courtrooms aren't always easy with access. So we'll just keep it in mind and keep following this case here on the podcast with what happens next. It's going to be a while before this goes to trial. And as an important note on timing, just because the defendant waived his right to a speedy preliminary hearing doesn't mean he's waived his right to a speedy trial. That's another factor here that I didn't talk about earlier in the episode. When he waived his right to speedy preliminary hearing, that holds through the preliminary hearing. But once he's held to answer, the speedy trial clock begins. However, in California, that speedy trial clock is 60 days after being held to answer. And I really don't think that David or his lawyers are going to push or try to push this case to trial within 60 days. But if you see this case get held to answer this week and see it set as a pretrial hearing on a number of 60, like 0 of 60, 10 of 60, what have you, that's what that number means. It's the amount of days in the speedy trial clock because, well, that clock starts ticking once the defendant is held to answer. I hope this episode helped give some legal insight about what's going on in court in California, what it all means, what a preliminary hearing is, and what the evidence has shown so far. This case is going to get held to answer. It's going to get bound over for trial, and we will be talking about it more then. And now I hope you feel well informed about what's happening and are able to engage in this case, even though it really is one of the most difficult cases we have seen and one of the most difficult things we have seen in a minute. It is a horrific crime, and that is part of the reason we are covering it the way we are covering it. And with that, Law Nerds, thank you for being here. Thank you for being a Law Nerd. I will see you on stream this week. Lots to talk about. And of course, some of it is going to be DCI. Yes, we are going to talk more about band. It's band season. We're getting ready for finals. We're doing all the things. So of course, there will be some discussion of a little less heavy topic. Don't forget to get the Law Nerd app so that you can stay in the loop. And thank you to our sponsors so that we can cover the cases that you want to hear about, no matter what the topic is. It means a lot to me, and I appreciate it. I'll see you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.